I like how Joseph Anthony is on top of your screen.
Yeah.
Can you see her? I can't zoom into this, is it?
No, you can't just leave first. It will become big after you leave first.
ಟುಮಾರೋ ಆಗಲೇ ತುಂಬ ಮೆಮೊ ಇದೆ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ 2:30 ತಗೊಂಡು ಪ್ಲೀಸ್.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದೆ ನಾಳೆಗೆ ಅಂತ.
ಹಾ
ಮೆಮೊ ಹೋಗಿರ್ಲಿಲ್ಲ ಸ್ಕ್ರೂಟಿನಿಗೆ. ಅಮೆಂಡ್ಮೆಂಟ್
ನೋಡಲ್ಲ ಎಷ್ಟೊಂದು ತಗೊಳಕ್ಕಾಗುತ್ತೆ.
ಶುಕ್ರವಾರಕ್ಕೆ
ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಲೀಗಲ್ ಪೊಸೆಷನ್ ಕೇಳ್ತಾರೆ ಪ್ರೇಯರ್ ಅಲ್ಲಿ, ಆಮೇಲೆ ಡಿಲೀಷನ್ ಕೇಳ್ತಾರೆ, ಪಾರ್ಟ್ಲಿ ಅಲ್ಲಿ ಆಗುತ್ತೆ. ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ನಾನು ಸ್ವಾಧೀನದಲ್ಲಿ ಇದೀನಿ ಅಂತಾರೆ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಅಲ್ಲಿ. ಸೊ ಕಾಂಟ್ರಡಿಕ್ಟರಿ
ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ಅಕಸ್ಮಾತ್ ಬಂದಿಲ್ಲ ನಾಳೆ 10:30 ಮೂವ್ ಮಾಡಿ 2:30
ಪ್ಲೀಸ್.
My lord,
May I
morning.
also move one
Morning.
memo, Your Lordship?
My lord, morning I have moved my memo.
ಸೇಮ್ ಅದು ಅದೇ
Garnish order is there.
ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಸರ್. ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಎಸ್
So, my lord, morning I,
ಅದೆಲ್ಲ ಫಸ್ಟ್ ಮಾಡಿರೋದು ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಟು ಪೋಸ್ಟ್ ಇಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. ನೋ ಹಿಯರಿಂಗ್ ಇನ್ ದೋಸ್ ಕೇಸಸ್.
my lord, fresh matter. Morning I moved the memo.
If it does not come, you move it tomorrow at 10:30.
Okay.
Announcement.
Announcement of order.
No, my lord.
Course number 1.
Appear for the petitioner.
Raghavan sir is logged in.
Yes.
I appear for
For
the
the respondent, my lord.
Raghavan sir is in the United States. All right.
Yes, my lord.
On the submissions made, I have framed the following issues. I will read them. Whether the march of human civilization from the days of the yore till the present digital age has ever witnessed information and communication in an unregulated state, or whether regulation has been its constant companion across epochs. Whether the regimes of regulation that prevailed in earlier times continue to subsist both with the local context of our polity and in the global order of nations. Whether right to free speech as enshrined under Article 19(1)(a) of the Constitution of India is an unbridled entitlement, or whether stands hedged by the canopy of reasonable restrictions as embodied in Article 19(2). Whether the jurisprudential edifice of the United States of America may be transplanted without reservation or adaptation into the soil of the Indian constitutional thought. Whether there has been discernible shift in American judicial philosophy in the aftermath of the celebrated decision in the case of Renault versus ACLU, and if so, to what effect upon comparative jurisprudence. What were the rules that fell for consideration before the apex court in Shreya Singhal versus Union of India, and whether in the contemporary context the rules now occupying the field are materially distinct, thus demanding a fresh interpretative lens. Whether the present challenge to the rules or their constitutionality is vitiated by the alleged vagueness, or whether the rules withstand the test of clarity and definiteness in law. Whether the fundamental rights guaranteed under Part 3 of the Constitution are to be regarded as essentially citizen-centric, or whether they extend in their sweep to all persons. Whether Sahyog portal envisaged under the Information Technology Act is ultra vires the parent enactment, or whether it stands as a legitimate instrument in aid to statutory purpose. In contemporary digital milieu, where algorithms increasingly shape the flow of information, its autonomy can eclipse the guiding hand of human agency. It's a myth or a reality. Whether the menace of social media needs to be curbed and regulated. I'll read the summary of findings. Summary. From Orient to the Occident, the march of civilization has borne witness to the inescapable truth that information and communication, its spread or its speed, has never been left unchecked and unregulated. It has always been the subject matter of regulation. As and when technology developed from messengers to the postal age till the age of WhatsApp, Instagram, and Snapchat, all have been regulated by regulatory regimes subsisting then and subsisting today, both globally and locally. Article 19(1)(a) of the Constitution, right to free speech and expression, is hedged by restrictions under Article 19(2) and is always subject to those reasonable restrictions. American jurisprudential edifice or American judicial thought cannot be transplanted into the soil of Indian constitutional thought is a clear law enunciated by the apex court right from 1950 till this date. The judicial thought process has undergone a complete change in the realm of free speech, even in the United States of America, in the aftermath of the judgment of Reno versus American Civil Liberties Union. Article 19 of the Constitution of India, noble in its spirit and luminous in its promise, remains nevertheless a charter of rights conferred upon citizens only. The petitioner who seeks sanctuary under its canopy must be a citizen of the nation, failing which the protective embrace of Article 19 cannot be invoked. Sahyog portal, far from being constitutional anathema, in its truth is an instrument of public good. Conceived under the authority of Section 79 3B of the IT Act and Rule 3D of the 2021 rules, it stands as a beacon of cooperation between the citizen and the intermediary, a mechanism through which the state endeavors to combat the growing menace of cybercrime. To assail its validity is to misunderstand its purpose, hence the challenge is without merit. The judgment in Shreyas Singhal predicated inter-alia upon the reasoning in Reno cannot by judicial alchemy be transposed into the present controversy. Reno itself has been diluted in subsequent pronouncements of the American Supreme Court. Shreyas Singhal spoke of 2011 rules now consigned to history. The 2021 rules, fresh in their conception and distinct in their design, demand their own interpretative frame, unsaddled by precedents that address the bygone regime. Social media, as a modern amphitheater of ideas, cannot be left in a state of anarchic freedom. Regulation of information in this domain is neither novel nor unique. The United States of America regulates it. Every sovereign nation regulates it. And India's resolve to likewise cannot by any stretch of constitutional imagination be branded as unlawful. Unregulated speech under the guise of liberty becomes a license for lawlessness. Regulated speech, by contrast, preserves both liberty and order, the twin pillars upon which the democracy must stand. No social media platform in the modern day agora may even feign the semblance of exemption from rigor of discipline of the laws of the land. None may presume to treat the Indian marketplace as a mere playground where information can be disseminated in defiance of statutes or disregard to legality, and later adopting a posture of detachment or a hands-off. In the light of the observations made in the course of the order, the content on social media needs to be regulated, and its regulation is a must, more so in cases of offenses against women in particular, failing which the right to dignity, as ordained in the constitution of a citizen, gets railroaded. We are a society governed by laws. Order is the architecture of our democracy. Every platform that seeks to operate within the jurisdiction of our nation, which they do, must accept that liberty is yoked with responsibility, and the privilege of access carries with it the solemn duty of accountability. To hold otherwise is to imperil both the rule of law and the fabric of social harmony. The petitioner's platform is subject to a regulatory regime in the United States of America, its birthplace and footland. Under the Take It Down Act of the United States, it chooses to follow the said act as it criminalizes the violation of orders of takedown. But the same petitioner refuses to follow the same in the shores of this nation of a similar takedown orders which are founded upon illegality. This is sans countenance. The petition, for all the aforesaid reasons lacking in merit, stands rejected. The applications of the interveners for the very reasons rendered in the course of the order stand rejected.
Immensely grateful, my lord. It was
Grateful.
indeed privilege, my lord, assisting your lordship.
My lord,
Thank you for
I
the
share my lord,
illuminating
fully.
submissions of both the petitioner and the respondents. Yes.
Lord, may I only
I
make
share
one
fully, my
request?
lord, the sentiment expressed by the learned solicitor, my lord.
Yes, yes.
Lord,
The
Grateful
court
to
is grateful, sir. Yes.
Great.
But the union had
But
made a,
ನಾಳೆ ಆಗುತ್ತೆ.
Lord, the
Upload
union,
ಮಾಡೋದು ನಾಳೆ ಆಗುತ್ತೆ.
please, union had made a statement that they will not precipitate matters on the Sahyog portal. If that be continued for 2 more weeks, it's my only request.
See, once I've passed an order, Kashtal.
Very,
I'll release it tomorrow, because it's quite a lengthy one.
please, please,
I'll release it tomorrow.
please, please.
By tomorrow evening, it will be on the website.
So grateful.
Yes.
So
Grateful.
grateful.
Let's continue. ಬಂದಿದೆಯಾ ಇದು 233 ಮ್ಯಾಟರ್ಸ್? ಒಂದು 3 ತಗೊಳ್ಳೋಣ, ಒಂದು ನಿಮಿಷ ಆಮೇಲೆ ತಗೊಳ್ಳೋಣ. ಅದೊಂದು ಫರ್ದರ್ ಇದಿತ್ತಲ್ಲ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋಣ, ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ ಕೊಡಿ. ವಿಲ್ ಜಸ್ಟ್ ಫಿನಿಶ್ ದಿ
Continue. 76.
ಎಲ್ಲಿ ಪೆಟಿಷನರ್
75 ಆಗ್ಬೇಕು.
75 ಅದೇ ಲಾಸ್ಟ್ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದಲ್ವ?
ಹೌದು.
ಹಾ ಎಸ್ ಸರ್.
ರೆಡಿ.
ಮೇಡಮ್ yes sir.
Yes, ma'am.
There's a vacating stay application.
Yes, ma'am. My lord, we have filed the dates.
Last time I had heard this matter for some time.
No, my lord.
No?
No.
All right, yes.
This is a case, my lord, where I am the owner of an estate, and I have my lord is pleased to hear.
Suit is for injunction.
Suit is for injunction by
Then-
me, and I had entered into an agreement with the defendant. I was supposed to deliver possession to the defendant only if he paid the money. My lord, in a connected matter, it came up before my lord because
Sure.
yes. The defendant, my lord, had collected money from third parties, and the money was lying with the RBL bank. And then, based on the compromise, the money was returned to the defendant. Therefore, my lord, the defendant has not paid a single rupee to the plaintiff. Now,
Defendant is the
Yes, my
respondent.
lord. And the defendant, my lord, had come before this honorable court saying that there are proceedings against me under Sarfasi Act. Therefore, please protect me. In the first instance, this honorable court was pleased to grant an interim order directing that he need not be dispossessed. Now, using that, my lord, he has started claiming rightful possession of the property. The RBL bank came before my lords and said, we have not commenced any proceedings under 13.2. We have not taken possession under 13.4. Therefore, the question of filing a writ does not lie. And the writ petition also came to be dismissed. Now, in the first instance, there was an injunction order granted in my favor. Then, as against which he went on an appeal. The appellate court, my lord, was pleased to modify the order. My lord is pleased to see page 80. Page 80, my lord, is the operative part, is against which the first writ petition is filed by the defendant. The appeal preferred by the appellants under so-and-so, that is the defendant, the interim order is confirmed other than the house structure as reflected from the photos available. So as against this, they have come on appeal. I have come on appeal on the limited fact that even regarding my house, he could not have claimed any possession because there's no registered agreement. I have never delivered him possession. His entire case is based on the fact that according to him, the bank has delivered possession to him. But bank was never in possession.
No.
My lord, bank has never. Bank has filed an affidavit. Has filed an affidavit before the writ court saying that we have.
Will consider. Yes.
Can I take?
Yes.
Yes, my lord, I have filed dates and events, my lord is pleased to see.
Yes.
That is on 29/7/25, my lord. My lord, on 13/8/2020, a tripartite agreement was entered into.
Page
That's at
70.
My lord, this is a
Memorandum
memo
of understanding.
Please, my lord.
Memorandum of
Yes,
understanding.
yes.
Yes, page 70.
70, my lord. Yes, my lord. My lord is pleased to see page 81. That is the memorandum of understanding. And please see clause 6. The buyer shall within 30 days of the vacation of the interim order, so and so. And then it says that the vendor declares that except the dispute between clause 8, upon the dispute between the parties and Lakshmi Vilas Bank, there is no other disputes. My lord, subsequently, we entered into a sale agreement, which is at page 97. And in this, my lord is pleased to see clause 3.1. The purchaser has paid a sum of rupees 1 crore as an advance amount by way of check bearing so and so, an additional deposit of 50 lakhs in favor of RBL Bank Limited. He has not paid me any money. Now, please see clause number 6, my lord. Sorry, clause number 7, possession and title documents. The vendor shall hand over physical vacant possession of the property to the purchaser simultaneously with the execution of the sale deed. Therefore, I have never delivered possession to him prior to this particular date.
I will see. Yes. Amal.
Yes, my lord. My lord, after that, my lord, I filed my suit on 21/9/21, which is at page 119, where I filed a suit for injunction. My lord, at this stage, the RBL Bank, my lord, which is at page 117, that is at annexure F, they notified the defendant that in spite of the interim order being vacated insofar as debt recovery tribunal, he has not made any payment. My lord, after that, the defendant filed writ petition number 19489 of 21. And this I request my lord to kindly see page number 7 in IA number 1 of 23, my lord. IA 1 of 23. This is a writ petition filed by him. And the writ petition, my lord, came to be dismissed at page 7 on 17th December 2021. And I request my lord to kindly see paragraph number 7, which is at page 10. In light of the submissions made by the learned counsel appearing for the parties, considering that it's not in dispute the respondent so and so, the private bank, submission is also made by learned counsel appearing for the respondent number 1 that the respondent number bank has released from mortgage before filing the writ petition. That apart, they are not amenable to the writ jurisdiction. So there was no proceedings. There was no 13(2) proceedings as against them. Then my lord is pleased to see page 13. The entire loan is closed out and we have returned all the money to the bank. So there was no subsisting loan, my lord. My lord, in my compilation of documents, my lord, request my lord to kindly see document number 5, page number 24. Page number 24, that is an order passed by my lord, where the very same defendant, whatever money he had deposited in escrow, he had taken it from third parties. So the third parties had filed a complaint before the jurisdictional police. An FIR came to be filed, as against which he filed a writ petition before this honorable court. And my lords, while quashing the proceedings, please see in page 26, petitioners and the second respondent, my lord, I am the third respondent at page 25. The petitioners have today handed over 2 checks bearing number so and so from Mr. Dinesh. It is submitted that petitioners agree to ensure that the said check shall be honored. It is submitted that respondent number 2 is returning 5 undated checks to the petitioner. The details are hereunder.
Those are other proceedings. Why are you here?
The advance, what I am submitting for my lord, that he
So
has...
what is it that you have challenged here?
My lord, they have challenged at page...
You have challenged. You are the petitioner in this.
No, there are 2 petitions. One is
One
filed
is by them, one is by you.
Yes, I am challenging the finding of the first appellate court with reference to them being in possession of the house.
Ashtatan.
That's all. They are challenging the remaining part of the order.
Yes, sir.
So far as my possession in the property is concerned, is not at all under dispute. This plot is known as Bhutanakadu Estate.
Hmm.
Bhutanakadu Estate is the subject matter of the agreement of sale.
Hmm.
And it is forming part of Balaji Estate, Balaji Plantation. Now kindly look at the cast title of
In this suit,
in the present writ petition as well as in the suit.
Hmm.
The present writ petition as well as in the suit, I have been described as residing at Balaji Plantation, Bhutanakadu Estate.
Hmm.
There is no dispute about my possession. And secondly, I would like to bring to the notice of this honorable court the notice issued by RBL Bank, which is produced as annexure F. Number writ petition. The writ petition is 5972 of 2023. Annexure F at page 117. This is dated 12th October 2021. It's a very short letter. I will read to the honorable court.
complainant petition.
Please. As per the terms of memorandum of understanding,
ಅದು ಇಲ್ಲೂ ಇದೆಯಲ್ಲ. ಎಸ್ ನಿಮ್ದೇ ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
right, page 117,
ಹ್ಮ್.
annexure F.
ಹ್ಮ್.
Page 117.
ಹಾ.
And this is addressed to the petitioner whom I am representing and written by RBL Bank, which is a party to the tripartite agreement. As per terms of memorandum of understanding dated August 13, 2020, executed between owners of Balaji Plantation, RBL Bank and yourself. Please note that balance consideration for enterprises had to be paid within 30 days of vacation of the interim order by Honorable DRT at Bangalore. Interim order. Please note that the interim order has been vacated on December 2020, and despite repeated reminders from bank, you have not paid the balance consideration for purchasing the estate. I will just stop for a moment. I am not a party to the dispute before the DRT. In any of the disputes, I was not a party. In fact, the bank has got attached all the property which were the subject matter of the mortgage, and they were holding the charge. Then, due to inordinate delay in remitting the balance proceeds to the bank, a notice was served to you on March 9th, 2021 to settle the balance dues within 10 days. As the bank has not received any communication and agreement got expired on the MOU executed was cancelled. In the meantime, again, you have approached the bank over a phone call on 7 September stating that you have remitted additional INR 1 crore rupee over and above initial advance of rupees 1 crore and taken a confirmation for the same from the bank with an assurance to pay the remaining within a week. Due to the inordinate delay, we have reached out to over a call, and you have personally visited on our Residency Road, Bangalore region office 6th October 2021 along with your son and promised to pay the entire balance of 3.6 crores on 11th October 2021, which was not honored. Now the point is, as we have not heard anything from you thereafter, and understand you continue to occupy the estate, kindly notice this, you continue to occupy the estate and enjoy the harvest and other benefits without having any legal title. Under the aforesaid circumstances, we called upon to hand over the peaceful possession of the estate as is where is basis without causing any damage. In case of failure to do so, the bank is constrained to take legal action against you for illegally
Yes,
occupying.
that is a letter addressed to you.
This is a letter addressed to me by the bank. Then this is one aspect of the matter wherein the bank has clearly admitted that I am in possession of the property. Now kindly go to Annexure G, page 118.
Yes.
This is a notice issued on the basis of the complaint lodged by the petitioner in the other writ petition.
Yes.
Kindly Ulleka Vandu, DPO means District Police Officer, PGC, etc. That is the reference dated 2/9/2021. ಈ ಮೂಲಕ ನಿಮಗೆ ಸೂಚನೆ ನೀಡುವುದೇನೆಂದರೆ ನಿಮ್ಮಗಳ ಮೇಲೆ ಶ್ರೀ ನಿಶ್ಚಿತ್ ಬಿನ್ ಕೆಸಿ ಅಶೋಕ್ ಮ್ಯಾನೇಜರ್ ಬಾಲಾಜಿ ಪ್ಲಾಂಟೇಶನ್ ಭೂತನಕಾಡು ಚಿಕ್ಕಮಗಳೂರು ತಾಲೂಕರವರು ಸದರಿಯವರ ಬಾಪ್ತು ಬಾಲಾಜಿ ಪ್ಲಾಂಟೇಶನ್ ನೀವು ಅಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿರುವುದಾಗಿ ಆರೋಪಿಸಿ. ಅಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿರೋದು ಅಥವಾ ಸಕ್ರಮ ಪ್ರವೇಶ ಇಟ್ಸ್ ಎ ಮ್ಯಾಟರ್ ಟು ಬಿ ಡಿಸೈಡ್ ಬೈ ದಿ ಕೋರ್ಟ್, ಬಟ್ ಇಟ್ಸ್ ಎ ಫ್ಯಾಕ್ಟ್ ದಟ್ ದೇ ಮೇಡ್ ಎ ಕಂಪ್ಲೇಂಟ್ ದಟ್ ಐ ಹ್ಯಾವ್ ಬೀನ್ ಇನ್ ಪೊಸೆಷನ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ.
Suit is pending where
Suit is pending.
injunction would be decided. The observation is with regard to possession is what you say.
That, not only that, my lord, his contention is, please see para
That
5.
will be decided in the suit.
No, my lord, I request my lord to see. Para 5, page 9 of his writ petition. Para 5, my lord.
All right.
The properties in question were in actual possession and custody of RBL Bank Limited.
Yes.
Then he says in para 6.
ಅವರೇ notice ಕೊಟ್ಟಿದ್ದಾರೆ.
No. I request my lord to see.
They have issued a notice describing him to be in possession of the property without title because it was with the RBL Bank.
Can I show, my lord? I filed a memo. Please see para 8 in page 15, my lord. In my memo dated, filed on 29/7/25. This is an affidavit filed by RBL Bank before this honorable court. Para 8.
Yes. Page
15, 1/5.
Huh.
It is submitted that it is also being stated as a matter of record. The respondent has not, that is RBL Bank,
Has not commenced any
proceeding under the SARFACI Act against the petitioner.
Then what is that notice?
My lord, that is, I don't know how the plaintiff, defendant has managed it.
Oh.
I am saying for my lords that according to him, my lord is pleased to see, Securitization Act is the only way to take possession of the property. RBL Bank is not able to take possession of the property. They have never taken possession. There's an affidavit. Now, in his paragraph 5, 6, and 17 in the writ petition, and say similar in the pleadings before the trial court, his entire case is not that I delivered possession. His case is that RBL Bank delivered possession. Now, if he gets a letter or if he obtains a letter from RBL Bank, it cannot be under 53A as against me. My lord, I am the owner of the property. I have not received a copper coin from him. In a collateral proceeding, he had deposited certain money with RBL Bank, and under the orders of this honorable court, RBL Bank, which was holding that money, has returned it to him. Now, my lord is pleased to see my circumstance. It's a coffee estate. The trial court has said, the first appellate court has said, look here, insofar as the house is concerned, he's staying there, don't disturb him. Now, insofar as the coffee estate, he's coming and troubling me. My lord, it's a coffee estate.
That is the court will decide.
No, I'm saying, my lord, he cannot claim 53A possession because unless RBL Bank was in possession of the property, it is not for the defendant to say that I have taken possession under the sale agreement. His suit is against me. My lord, if RBL Bank was not in possession, please even see this, my lord, para 17 at page 1/5 of his writ petition.
Yes.
RBL Bank handed over possession to the petitioner, para 17.
Yes.
His entire case, para 5, 6, 17, page 1/5.
Yes.
Then even in his written statement before the trial court, please see page 130 to his writ petition, para 2.
Yes.
Here also he says, possession of the property was handed over to the defendant by RBL Bank. Then again in page 131 and 132, para 3. Defendant petitioner was ready to pay the amount, but the plaintiff respondent did not come forward to executing the sale deed. Now, even in his suit, which is at ink page 140, he files a suit for specific performance. Please see para 9. Here also he says, RBL Bank, by exercising its powers under SARFACI Act. My lord, RBL Bank is saying, sir, I have not exercised powers under SARFACI Act. Just one letter, stray letter, written by some person, My lord, if RBL Bank had taken a measure under 13, taken possession, and then delivered it to the defendant is one. But for the defendant to take advantage of some letter which has come in his possession and to now say under 53A, you have delivered possession of the property.
Anything else, sir?
I would like to bring to the notice of this honorable court the memorandum of understanding at page
Yes.
82
Mm,
in my writ petition.
yes.
In my writ petition, it's at page 82,
82, yes.
dated 13/8/2020.
Mm,
Kindly go to page 83.
mm,
Witnesses as follows. Whereas Mrs. Balaji Plantation, a registered partnership firm, bearing number so and so, so and so.
mm.
And kindly go to next page 84, schedule of properties. Whereas the vendor is carrying on the business of owning and manufacturing, maintaining coffee plantations, and whereas during the course of business transaction, the vendor had availed working capital facility and term loans from the bank on 22/3/2014.
ಅದು MOU ಲೇ ಇದೆ.
M1 ಎಲ್ಲ details
Page
details
92, para 12.
ಎಲ್ಲ details
Page 92, para 12. Please see, my lord.
Mm,
The bank at all times, second sentence, as a security holder shall have the right to enforce and take possession by following due process of law. That means on the date of MOU,
no, loan ತಗೊಂಡ್ರದ್ದು ಹೌದಾ?
I've repaid also. I've repaid. My lord, I showed my lord in the memo documents, I have repaid the bank the loan. That is why the bank came before this honorable court.
And said they have not initiated any surface.
Yes, and here para 12 of the MOU clearly says that. Para 12 at page 92, and take possession. And my lord is pleased to see, in an injunction suit by me, he cannot be granted an injunction.
I filed an application for
No,
injunction.
no, in my injunction
It's
suit,
page 167. Learned judge of the
separate
trial court
application
does not
ಹಾಕಿದಾರಲ್ಲ.
look
no,
at
no,
such
in
documents.
my suit, my lord, an injunction is for a date and event. His cause of action is different. So it is absolutely not correct from the first appellate court to say that an injunction filed by me, I am now suffering an injunction in my injunction suit.
We'll see, we'll pass. Archana sir?
My lord, some authorities are maybe.
Please. ನೀವು ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ.
Yes, ma'am.
Yes.
My lord, the first proposition is injunction cannot be granted in against the true owner in favor of a trespasser. That is Premji Ratan Singh.
So according to you, he is a trespasser.
It's a trespasser
We'll
at best. Second is, my lord, defendant cannot maintain an application under order 39 as against me. And my lord, test to determine possession under 53A.
Yes.
My lord, in fact,
That the court will decide it finally.
no, my lord is pleased to see, and just, I'm not going to take too much of time, my lord. This para 51, 50, page 51, 58, 62, 64, trial, the first appellate court has completely analyzed the fact and said that the defendant has not paid a rupee, there's no registered agreement, he is not in possession of the property, and therefore he cannot claim 53A as against me, and what he's pleading is from the bank. Let him collect the possession from the bank, not from me, my lord.
We'll see. We'll dictate.
Grateful.
Heard so and so. Post the matter on 23rd for dictating orders.
Please.
Next. Yes, next.
76.
ಯಾರಲ್ವಾ? Intermodal. No representation by the petitioner. List after vacation. Next.
77.
For the petitioner in this matter, my lord. My lord, I'm aggrieved with orders passed by the execution court wherein interest is calculated only until 18/12/23, my lord.
I need to file my objections with supportive documents, my lord.
Objection ಹಾಕ್ಬೇಕಾ?
ಹಾಕ್ಬೇಕು. ಅದರಲ್ಲಿ
They've sought some interim order
Interim
ಏನಿಲ್ವಲ್ಲ?
reliefs, my lord.
The learned counsel H. Chandrachud seeks 2 weeks time to file statement of objections. List the matter after 2 weeks.
I request for a date kindly.
14th?
Please, ma'am.
Yes.
Great.
78.
So in a suit for partition, application for injunction came to be rejected, against which appeal was filed. In the appeal, respondent files a memo without hearing the appeal on merits. The memo is recorded and appeal was disposed of. Page 58, my lord. Ink page 58. The learned
Respondent
counsel-
here.
learned-
Respondent is not present.
Mr. Prasanna Shetty. Mr. Prasanna Shetty.
List the matter on 15th October. Interim order subsisting will continue to the next day.
Please.
79.
Today I have received the wakalat. You have to file.
Learned counsel so and so undertakes to enter appearance for the respondent. Registry to print the name of so and so as appearing for the respondent. Interim order, yeah?
Interim order.
AVIO.
Maybe extend. Okay.
80.
Maybe posted after vacation, my lord. No entry matter, my lord.
List at the request of the counsel appearing for the petition, list after vacation.
81. Hearing on IA.
Yes, sir. Judgment.
Please. The very same judgments relied by him, my lords, the very same judgments.
I have passed an order, sir.
I could not lay hands
Section
on
8.
any of the orders, my lords, passed by my lords.
Huh?
I could
have.
not lay hands on any of the orders. Lords, that deals with 12A, my lords. What my lords has dealt with is under 12A. And my lords has held that it is an interlocutory order, and as such, section 8 would come into play. Where there's a bar of revision petition, my lords.
Section 34, sir.
Sorry?
Or what would come into play?
Section 8. Under section 8.
It's an
of the-
application seeking, rejecting an for reference to arbitration.
No.
ಇಲ್ಲಿ ಏನು ಇರೋದು?
Illi, I have filed, see, I am a co-defendant. Defendant number 1 files a counterclaim against the plaintiff and against the defendant as well, the second defendant. I'm the second defendant.
No, 1 minute, come back. The
Defendant
defendant
number-
has filed a counterclaim against another defendant.
Against a co-defendant.
Yes, sir.
My lords.
It's under, so I filed an application under 7 Rule 11 and sought for rejection of the
Of
counterclaim.
that particular
Of
counterclaim that is filed
particular-
against a co-defendant.
Against me.
Yes, sir.
My lords, it would be inappropriate to say that by my friend, my lords, because
One defendant cannot file a counterclaim
file.
against the other defendant.
file,
It's a
my lords.
settled principle of law.
yes, my lords, Rohit's
Yes,
case
sir.
holds that solely against the co-defendant, there cannot be any
Yes, correct.
counterclaim.
Correct.
My lords, if it is incidentally against the claim of the plaintiff as
Now
well
I
as,
will only record this submission and say that it will not come, your counterclaim insofar as the said this defendant is concerned is inoperable.
my lords, my factual matrix are like this, my lords, which is applicable in the Rohit's case applicable.
No, because I disposed this matter, he has moved it.
Yes.
I restored it now.
On maintainability, my lords, the point
that's
of
what I read.
maintainability, it was heard, if I'm right, my lords. And so far as, my lords, what has happened? Factual matrix is like this, my
No,
lords.
he himself said that it was not maintainable anta avaru ಹೇಳಿದ್ನ
What
dispose
happened, what
ಮಾಡಿದೆ.
transpired on
Then
that
of
day was,
course,
my lords,
wisdom is said
about
to have
three-
dawned.
No, 3-4 matters previous to me, a similar matter came up.
It's all right.
Where they, my lords, they withdrew the matter saying that there lies an appeal under section 13. I went through that section 13. If my lords would kindly peruse section 13 and section 8,
No, no problem. If it is against a co-defendant, we will not.
it is against a co-defendant.
My lords, my submission is,
Section
plaintiff-
13, my
Right,
lords,
we'll hear it after vacation.
please, my lords.
my lords, any date may kindly, because,
I'll fix that. also.
please,
Lord's kind permission, my lords. This, maintainability itself.
That we will
Section
answer
8
everything, sir.
Even on section
Maintainability is, see, if a counterclaim against a co-defendant is allowed by the court, 2227 is maintainable.
Please.
Anything else?
Revision
It
petition
cuts at the root of the matter. On the face of it, illegal.
My lords, kindly see section 8, my lords. There is a bar against revision application or petition against an interlocutory order.
We'll see.
Finding anything else.
We'll see.
My submission, it is not an
They've
interlocutory
stalled-
order at
I'm
all.
the plaintiff before the learned commercial court. My lords. And they've stalled the suit based on an application or a petition which is not maintainable. My lords, it's the shortest date. My lords.
We'll see. We'll fix it on 14th.
Please.
List
Interim order.
the matter on 14th to hear the parties, hear the petition and the respondent further. The interim order subsisting would continue to the next.
In both the matters, my lords.
Both 81
Serial
and
number 7 and this.
7 and 81 tag ಮಾಡಿ madam.
my lords, if I may submit one thing, my lords. The defense of the second defendant and defense of the first defendant. My lords, only prayers, if at all not maintainable. The suit need not be halted, my lords. The suit is posted for cross-examination.
We'll see till the 14th. ಅಲ್ಲೂ ರಜಾ ಇದೆ, ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತೀರಾ ಬಿಡಿ.
Great.
Because, my lords, this is on the nature of tripartite agreement where there are mutual rights and liabilities. That's what is observed.
Fair enough, but this submission, what he has said, counterclaim against a co-defendant.
Solely against not maintainable.
Yes, sir, definitely.
Solely not maintainable, my lords, but incidentally.
What you cannot do directly cannot be done indirectly. Sir. Yes.
Grateful.
14.
ಯಾವ್ದು order being spoken to ಇದೆಯಾ ಅದು? So and so.
7 and
The 7 ಅಲ್ಲಿ madam, the subject petition was disposed owing to the fact that an alternative remedy of appeal was available. The learned counsel for the petitioner in writ petition 81 so and so, which is a connected matter, had moved the matter on the score that the submission was erroneously made that an appeal remedy was available. According to the learned counsel, the appeal remedy is the appeal is not a remedy that is available under the statute, and would submit that he would convince the court. In that light, the order, the said order in criminal in CRP 679.
No, in both matters.
Hello, in 679 and 2025, oh, you're recalling it, yeah. Therefore, the order dated so and so in both these petitions stand recalled. Petitions are restored to file. List them on 14th. 14th interim order subsisting in these cases shall continue till the next date of hearing.
Yes. Grateful.
Madam? ಒಂದರಲ್ಲಿದೆ ಸಾಕು. ಇದರಲ್ಲಿ interim order ಬೇಕಾ? ಒಂದರಲ್ಲಿ ಇದೆಯಲ್ಲ?
There are two separate suits.
Sir, yes. In the light of the interim order subsisting in serial number 7, there shall be an interim order in 81 also.
Please.
ಅಥವಾ vice versa, what is it? 81 ಅಲ್ಲಿ ಇದೆ, 7 ಅಲ್ಲಿ ಕೂಡ ಅದ.
7 ಅಲ್ಲಿ ಇತ್ತು, 81 ಅಲ್ಲಿ.
Whatever.
82.
For respondent number 1, my lords.
My lord, this is
Application for
the
vacating interim.
amendment of the appeal, my lords. My amendment to appeal has been rejected, whereas the other appellant number 2 the amendment has been allowed.
ಚಂದ್ರಚೂಡ್ ಅವರು ಇದ್ದಾರೆ.
May I just place one judgment, my lords, of this ladyship?
ಪಾತ್ರ ಇಲ್ವಾ?
Para 16, my lords, of ladyship's judgment, my lords.
ಏನು?
She says, my lords, how the court must
This
take
is
into
caste certificate matter.
No, my lords, this is
Ilva.
on the amendment, my lords,
NCPC.
para 16. Para 16, my lords. Please look at, my lords, how the ladyship interprets order 41 and how the appeal must be, amendment to an appeal must be treated. When there's additional grounds that has been brought in, my lords, that must be allowed. And she says that it cannot be interpreted in a manner, written statement must be interpreted in order 6 rule 17. Para 16, my lords.
Uncontested defendant has filed application under order 6 rule 17, my lords, in the first appeal, my lords. His,
Generally should not be allowed.
his brothers and sisters have filed written statement and contested the matter. Similar set of facts has
ಅಲ್ಲ,
been.
partition individual right ಅಲ್ವಾ?
Filing the list of dates and events.
14th.
My lords, may I request?
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ? ನಾನು
ಇಲ್ಲ 8th ತಗೊಳ್ಳ.
ಅಲ್ಲಲ್ಲ ಅಲ್ಲ
No, small.
ಇದ್ರಲ್ಲಿ interim order may be modified, my lords. They are impeding and they are alienating the properties.
I have no property to alienate only, my lords.
Restraining them from alienating.
Don't alienate.
I
to the
have
next
no
date.
property to alienate, my lords. What will I alienate?
The learned counsel for the respondent submits that
Hardly
the
very share, my lord.
respondent submits that the petitioners are alienating the property, therefore they must be restrained. The learned counsel for the petitioner submits that he has no property to alienate, therefore he would not alienate anything. The submissions are placed on record.
Yes, my lords.
ಬೇರೆ ಬೇರೆ
Some other
respondents,
response are
ಬೇರೆ
doing, my lords. What will I do, my lords?
ಅವ್ರ ಕೇಸಲ್ಲಿ ನೀವು entry ಮಾಡೋದು.
ಅಲ್ಲಲ್ಲ ಬೇರೆ respondents, let there be modification of the interim order, my lords. First
ಏನು?
step
Some other
ಅಲ್ಲಿ
response.
ಬೇರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಮಾಡಿದ ಏನ್ ಮಾಡಕ, ಇವ್ರೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
entire proceedings in the area is state, my
That's
lords.
all right.
ಅಲ್ಲ
Yes.
final disposal of the.
That on, we will pass that order on 14th.
May I request for 8th, my
Respondent number
lords?
15 to
8th
21.
ಬೇಕಾ? 8th, yes, list on 8th.
Respondent number 15 to 21. Filing a list of dates and events.
Register, let it get into the file. ಇದು ಕೊಟ್ಬಿಟ್ಟಿಲ್ಲ. Learned counsel for the response 8 to 15 file.
15 to 21.
Li-
15 to 21.
15 to 21 list of dates and events, the same is taken on record. Yes, next.
Grateful, my lords. There is interim order, my lords.
Interim order subsisting would continue to the next date. Shobit,
83.
ಇದೇನೋ ಯಾರನ್ನೋ ಬರಕ್ ಹೇಳಿದ್ವಲ್ಲ?
Yes, my lord. In this matter, some development is there. He is
Ah.
supposed to give the document to show that that particular stretch along with the liability.
ಕೊಟ್ರಾ ಅದು?
Actually, there is no such document. They called me on.
Yes, sir.
Ultimately, what happened now? My submission is that, my lord.
Already got instruction from my client.
ಏನಂತ?
Yeah, what happened? Executive engineer outside, he collected all the information. Then he got to know that this particular stretch is handed over, but liability is not handed over. They called me also.
ಈಗ ಯಾರು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ತೀರಾ ಅವ್ರಿಗೆ
Have to
ಹೇಳಿ.
pay the compensation.
Who?
Respond number 1 and 2.
Ah.
Now,
By my lordship, the
Otherly-
ministry approval is required.
Which ministry?
Ministry of
Ministry of Road
ಈಗ ಯಾವಾಗ
Transport.
ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ, ಅದು ಅವ್ರ ಮುಂದೆ ಇಟ್ಟ ಮೇಲೆ
ಎಲ್ಲ ಇಲ್ಲ ಕಾಂಪನ್ಸೇಷನ್ ಯಾವಾಗ ಕೊಡ್ತೀರಾ, ರಿಲೀಸ್ ಮಾಡ್ತೀರಾ? ಆಟ ಆಡ್ತಿದ್ದೀರಾ ನೀವು ಇಬ್ರು ಅವ್ರ ಲೈಫ್ ಅಲ್ಲಿ?
As far as
ಲ್ಯಾಂಡ್ ಲೂಸರ್ ಲೈಫ್, ಬೋತ್ ಆಫ್ ಯು.
no, as far as NHA
Not
is
me, not
concerned-
me ಅಂತ you're
As far as
trying to
NHA
play.
is concerned, there is no such liability. I have received a document 2017, they have handed over. Now their
ಯಾವಾಗ
request is
ಅಕ್ವೈರ್ ಆಗಿದ್ ಲ್ಯಾಂಡ್ ಮೇಡಮ್?
97.
my lords.
Enhanced compensation they have not paid. My submission is that, my lord.
Is it not the system is put to shame?
No, my submission is that, my lord.
Hmm.
I'll also put a word to ministry. Now they agreed for.
1997 ಅಕ್ವೈರ್ ಆಗಿದ್ದು ಇನ್ನು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ದಾಡ್ತಾ ಇದ್ದಾರೆ. Is it not the system being put to shame?
That is the reason, my lord.
What that is the reason?
My submission is that, my lord.
ರೆಕಾರ್ಡ್ ಇವ್ರು ಕೊಟ್ಟಿಲ್ಲ, ರೆಕಾರ್ಡ್ ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರು ಕೊಡಬಾರ್ದು, ಇವ್ರು ಕೊಡಬಾರ್ದು. What is all this?
Now government is requested for 4 weeks to 6 weeks time. Meantime, this matter may be pending. So otherwise, as my learned friend said, if matter is disposed of here, they may
No,
not
I will
make
not
the
dispose
payment.
it.
That's the reason. Kindly
Dispose
have it
ಮಾಡಿದ್ರೆ
after
ನಿಮ್ಗೆ
4
ಏನು
weeks.
ಬರಲ್ಲ ಮೇಡಮ್. Wait.
That is the reason. I requested her
4 weeks,
also.
my lordship.
List the matter on 31st October for further hearing at 4 p.m.
Yes, my lord.
On the submissions of both the learned counsel to the petitioner and the respondent state that compensation by the next date would be dispersed in accordance with law to the land loser by the appropriate authority.
Respond number 1 and 2, they.
By appropriate authority, which according to the counsel for the petitioner is respondent 1 and 2, which is accepted by the counsel learned AGA.
Our party like.
In the event the compensation is not released by the 31st of October, appropriate orders would be passed mulcting the state for having kept the land loser out of compensation for the last 20, close to 20 years, 30 years, huh? Close to 30 years. Yes.
Yes, ma'am.
ಒಂದು 25 ಲಕ್ಷ ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ, ಅವಾಗ ಗೊತ್ತಾಗುತ್ತೆ. ಎಸ್.
84 addendum, 85 reporting settlement, 85.
Respondent.
Lordship,
ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ವಾ?
they want to purchase.
Given a proposal, my lord.
Ah.
The scheduled property totally measuring 1000 square feet. There are 6 shareholders.
ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಆಗುತ್ತಾ ಇಲ್ವಾ?
No, no.
ಅಷ್ಟು ಹೇಳ್ಬಿಡಿ ಸಾಕು.
No settlement. Like only one submission.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್, ಅವಾಗೆಲ್ಲ ಕೇಳೋಣ.
Yes, ma'am. Only one submission. Like the Supreme Court has already granted 4 months to dispose conclude the FDP proceeding before trial court. The 4 months is already over, my lord. Now the action is also held. Earlier action.
Then we will not hold the proceedings here. We'll close it.
Let me kindly see page number 30, my lord.
ಏನ್ ಇಂಟರ್ ಮಾಡಿದ್ಯಾ?
Interim order.
Oh, that will be vacated immediately. ಕೊಡಿ ಮೇಡಮ್.
Page number 30, my
When there is already an order to dispose, we will not stall it.
Your Lordship, that
4
was,
months time has been granted and that is over.
that
my
was
lord.
the writ petition filed in the year 2024.
Yes, my lord.
This is in 2025.
Yes.
ಅದು
This
ಗೊತ್ತು.
is completely on a different,
What different?
section 3 application, Your Lordship.
ಅದು who should get the first right
Partition Act.
over the
Section
sale,
3.
partition act ಅಲ್ಲಿ. ಈಗ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
My lord.
That has been dismissed.
Who, you are the claimant?
I propose to purchase the entire property.
My lord, what happened, my lord? Earlier purchase, they says that there is some irregularities. My lord, this honorable court noting, considering all the facts, my lord, this honorable court
Anyway,
has.
list the matter on 8th. It is made clear that it would be heard. This court, the coordinate bench of this court on 14th November 2024 had already passed an order directing the concerned court to dispose the petition. Again, the petitioner is back to the defendant there. Defendant Aurena. Again, the petitioner is back to the doors of this court on contending that it is on a different plea altogether. Therefore, list the matter on 8th. It is made clear the matter would be heard and disposed.
Your Lordship, interim order.
Interim order subject to the aforesaid shall continue to the next date. Next.
Stating orders 86.
ಯಾವಾಗಿಂದ ಅಪ್ಲೈ ಆಗುತ್ತೆ ಅಂತ?
It may not be from the date of disposition till publication of preliminary notification.
ಅದು ಕರೆಕ್ಟ್.
Correct.
At what rate?
Quantum is concerned.
At what rate?
Correct. Quantum is concerned 15% after total compensation. That was 1 month. 2014 SEC ಒಳಗೆ that was categorically.
That is Balwant Singh.
ಬಲವಂತ್ ಸಿಂಗ್ ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ
ಮುಂಚೆ ಒಂದು
ಬಲವಂತ್ ಸಿಂಗ್ ಕೇಸ್ನೊಳಗೆ it is on the land value, the way it is referred to it went to the Supreme Court based on the reference award. But in other matter, it is award passed by the determining authority. ಈಗ 2000
So according to you, compensation determined value ಗೆ 15% ಕೊಡಬೇಕು.
land total compensation.
Total compensation.
The latest judgment on the point is 2024 Supreme Court.
Correct, yes.
That is my lord,
ಇಲ್ಲಿ ಯಾವ್ದೋ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
ಅಲ್ಲ ಅದಲ್ಲ, ಇದು ರಾಜಾ and the Union of India versus ರಾಜಾ.
ರಾಜಾ ಕೊಡಿ.
This is a matter reached to Supreme Court for Jammu and Kashmir High Court judgment. Where it was decided that the compensation.
ಇಲ್ಲಿ it is said again on the compensation amount.
Yes.
I'll go through the documents.
Go through now.
In which document which we have given, that is the
Document alla sir, judgment.
Judgment which we have given, Mala.
No, they have also given a judgment. It's judgment versus judgment. ಏನು go through ಅದ್ರಲ್ಲಿ?
Alla, it is of the year 2016.
Sir, 2024.
20 ನಮ್ ಕೊಟ್ಟಿಲ್ಲ.
You should be updated with laws.
Sir, please,
what is this?
It is only with regard to land value. The court has directed.
ಈಗ ಲ್ಯಾಂಡ್ ವ್ಯಾಲ್ಯೂನ ಅಥವಾ ಕಾಂಪನ್ಸೇಷನ್ ವ್ಯಾಲ್ಯೂನ ಅಷ್ಟೇ ಡಿಟರ್ಮಿನ್ ಮಾಡಬೇಕಾಗಿರುತ್ತೆ ಅಲ್ವಾ?
ಹೌದು, ಮಾಡುವ. That is the only.
Kashmir High Court said 15% on damages on compensation determined so and so. That was the challenge matter was taken to the Supreme Court.
Supreme Court has affirmed it.
Balwant Singh, it is in the year 2016.
Balwant Singh consider ಮಾಡೇ ಬರ್ದಿರೋದು.
Balwant Singh consider ಮಾಡಿದ್ದಾರೆ.
If there is anything, my lord, I will.
There is nothing, sir.
No, I will, my lord, I have not seen this judgment.
Hey, why do you need this? It's law, sir, of the Supreme Court. You don't
Maybe,
need
my
to
lord,
see
I will go through that. And if there is anything, my lord, I will submit to the court the judgment.
ನೀವು ಕಾಪಿ ಮುಂಚೆ ಕೊಡ್ಬೇಕು ತಾನೆ? Compensation will not adjourn.
My lord, I agree, my lord. Compensation to be determined on the land value, which is very
Land
clearly-
loser's fate
My lord,
cannot hang in balance at all.
Please, my lord, may I make one submission, my lord, the representation which they have given, and the order of this honorable court, my lord, to consider the Balwant Singh order and pass the.
That's all right. Supreme Court has written something else. Subsequently, the order of this court gets subsumed by the order of the Supreme Court.
Please, my lord, I will go
Anything
through
else?
this. I will go through this, my lord. If there is anything other than this, my lord, I will.
No, all right.
Submit to
We'll post it on.
Tomorrow. You can go by 24 hours. 5 ನಿಮಿಷ ಸಾಕು. ನಾನು
ಅಲ್ಲ.
5 ನಿಮಿಷಕ್ಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ.
ಅವರು
ನೀವು ನಾಳೆಗೆ ಹಾಕ್ತಾನೆ ಇರಲಿಲ್ಲ ನಾನು. ಪಾಸ್ ಓವರ್. ಓದ್ಕೊಂಡ್ ಬನ್ನಿ. Yes, yes. 5 ನಿಮಿಷ ಸಾಕು ಓದ್ಕೊಂಡ್ ಬನ್ನಿ.
Tomorrow, my lord. Tomorrow.
You can't read in the day, is it?
No, not like that.
Then?
My lord, tomorrow.
Go and read and come, sir. 2 ಪೇಜ್ ಜಡ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲಿ. ಅದನ್ನ ನೀವು ಅಥಾರಿಟೀಸ್ ಕಳಿಸಿ ಅವರು ಒಂದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡಿ ಅವ್ರು ಹೇಳಿದ್ದನ್ನ ನೀವು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
Authorities ಕಳ್ಸಲ್ಲ ಸ್ವಾಮಿ. I
ಹಂಗಾರೆ
will go
pass
through, I
over.
will check, my lord. I will
Coffee
take
ಕೊಡ್ಸಿ.
something. Today they have given.
Over a cup of coffee, read and come.
Tomorrow, my lord.
Coffee I
Yes.
can pay the cost of.
Correct.
I will
Damages ಕೊಡ್ಬೇಕಾಗಿಲ್ಲ.
Tomorrow, I'll go through this judgment. If there is anything.
If there is
else,
any
my lord,
difficulty, come back at 5:30.
If there is anything, my lord, tomorrow I will.
Come back at 5:30.
Please.
Yes. ನೀವು ನಾಳೆಗೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ ನನಗಂತ ನಾನು ಬೇಗ
ಅಲ್ಲ,
ಅಸ್ಯೂಮ್ ಮಾಡ್ತೀನಿ
ಅಲ್ಲ,
ಆಗ್ಬೋದು.
I will go, I will research something, my lord. If there is, I will also.
I may be wrong on that.
I will research, my lord. If there is anything, I will submit. If not.
ಬೇರೆ ರಿಸರ್ಚ್ ಇಲ್ಲ ಸರ್, ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ನೀವು ಅದನ್ನ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ. ಟೈಮ್ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ ಆಮೇಲೆ.
Please.
ಫಸ್ಟ್ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ.
Please.
Further hearing 87.
I
ಯಾವ್ದು?
filed the inquiry report also. At the last occasion, this court has.
No, ಇದು it is posted for 3 months ಆಗೋಗಿದೆ ಅಂತ ಅಷ್ಟೇ.
ಇಲ್ಲ 2018 ಇಂದ their promotions. have been
Promotion,
written.
yes. Prasad sir.
Yes, my lord.
I
They
filed the
produced one,
inquiry report.
document, departmental inquiry. Earlier also I submitted same thing because 2 departmental inquiry.
ಇದು ರಿಸರ್ವ್ ಮಾಡಿದ್ದೆ.
Yes.
ಹೌದೌದು. ನಾನು ಅದಕ್ಕೆ ನಾನು
Earlier
inquiry
also I
report
submitted same thing, my lord. 2
ಇವತ್ತು
departmental
ರೈಪ್
inquiry.
ಆಗಿದೆ ರಿಸರ್ವ್ ಮಾಡಕ್ ಮಾಡಿ. ಹರ್ಡ್ ರಿಸರ್ವ್ಡ್. ಮೇಡಮ್ ಇದೆಲ್ಲ ರಿಸರ್ವ್ ಆಗಿದೆ.
Further hearing. 88.
My lord, this matter was reserved for judgment.
Yes, it's
89.
only for the date. We'll all re-reserve it. ಅದೊಂದು ಮಿಸ್ ಆಗಿ ಬಂದು ಎಸ್ ಆಯ್ತು ಆಫ್ಟರ್ ವೆಕೇಶನ್
90.
And for the respondents, 2 to 4, my lord.
ಹಾ ಮಾಡಲ್ವಾ
And he was here up till now, but because of inconvenience, he had to go away. Anytime during second week after vacation, my lord. Because first week he will not be available.
ಟ್ಯೂಟರ್ಸ್ ಮತ್ತೆ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ?
He will not be available in the first week. He will not be available in the even.
ಅಲ್ಲ ಆಯ್ತು, ಈಗ ಬೇರೆ ಟ್ಯೂಟರ್ಸ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ
ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ 100% ಮಾಡಿಲ್ಲ.
Shall I record that?
No, yes, you can record.
The learned counsel appearing for the respondent submits that in place of these petitioners, no further appointments have been made to the post of tutors in the institute. Therefore, list this matter on 23rd.
Allah, soon after.
Soon after vacation, andre
Second week. That's what he has asked.
third week ಅಂತ ಹಾಕಿದೀನಿ, ಪರವಾಗಿಲ್ಲ ಬರ್ಲಿ. ಏನೋ ಅಪಾಯಿಂಟ್ ಮಾಡಿಲ್ವಲ್ಲ ಯಾರನ್ನು?
91.
ಅಷ್ಟರಲ್ಲಿ ಅಪೀಲ್ ಯಾವಾಗಿರೋದು? ಡಿಸೆಂಬರ್ ಬಿಡಿ, ತೀರ್ಮಾನ ಆಗುತ್ತೆ. ಇಲ್ಲಿ ನಾನೇ ತೀರ್ಮಾನ ಮಾಡ್ತೀನಿ ಅಷ್ಟರಲ್ಲಿ.
For the respondent number 1 and 2,
for petitioner, my lordship, kindly written after vacation, my lordship. We are engaging the senior counsel.
You are engaging. ಇದು 10ನೇ ಸರಿ ಬರ್ತಾ ಇದೆ. You are engaging ಅಂದ್ರೆ ಬೈ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ಸ್ ಇರೋದು.
One chance, my lordship.
any date after that, your lordship, we are also being led by C.
Yes, we'll list it on 24th. List on 24th.
Please, ma'am.
Same for further hearing.
92.
ಇದೇನು? ಇದು ಕರೆಕ್ಟ್. ಎಲ್ಲಿ ಗವರ್ಮೆಂಟ್
Filed the statement of objection.
ರಿಜಾಯಿಂಡರ್ ಹಾಕಿದ್ದೀರಾ ಅದಕ್ಕೇನಾರು?
Rejoinder ಹಾಕಿಲ್ಲ ನಾವು ಸ್ವಾಮಿ.
ರಿಜಾಯಿಂಡರ್ ಬೇಡವಾ?
In fact,
ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ತೀರಾ ಇಲ್ವಾ?
AG will come and argue.
ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಕ್ಕೆ ಅವರೇ ಬರ್ಬೇಕಾ?
Argument ಅವರು ಮಾಡ್ತಾರೆ.
AG.
AG.
After filing of this writ petition, it seems that now the state has woke up and according to, as per the statement of objection, now they have taken decision to file
release compensation.
Miscellaneous appeals before the concerned district court.
We'll answer.
And now they are, now they are willing to file writ appeals, and then only they can able to come out with a perfect statement of objection. That is the.
ಅದು ಹಾಕ್ದಾಗ ನೋಡ್ಕೊಳ್ಳೋಣ, ಅಲ್ಲಿವರೆಗೆ ತೀರ್ಮಾನ ಮಾಡ್ತೀನಿ. List the matter on again 24th. It is made clear no further adjournment will be granted to the state on any score whatsoever. Interim order illalla?
In fact, what we have requested, directed the state to at least make part deposit.
Adralla irli bidi. We'll see. Yes.
93.
Petitioners.
Queen City.
May only place some interim protection after.
Interim ಏನು? Coconut, arecanut, vegetables, flowers.
ಬುಲ್ಡೋಸರ್ ತಗೊಂಡ್ ಬಂದ್ರೆ ನಮ್ಗೆ ಏನು ಕೋಕೋನಟ್
ಏನು ಇಲ್ಲ. ಬುಲ್ಡೋಸರ್ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
ಸ್ಟೇಟಸ್ ಕೋ ಅಂತ
ಇಲ್ಲ, ಅವರೇ ಸ್ಟೇಟಸ್ ಕೋ ಡೇಂಜರಸ್ ವರ್ಡ್. ಏನ್ ವಾಟ್ಸ್
ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕೊಂಡ್ರೆ ಇನ್ನೊಂದು 2-3 ಇದೆ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಅಲ್ಲಿ ಜೊತೆಗೆ ಎಲ್ಲ ಒಟ್ಟು
ಕೊಡಿ, ಎಲ್ಲ ಕೊಡಿ.
ನಾನು ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಅಲ್ಲ ಇನ್ಯಾವ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್?
2-3 ಸೇಮ್
ನೋಟಿಫಿಕೇಶನ್.
ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್.
ಆಯ್ತು, ಈ ತೀರ್ಮಾನ ಆಗ್ಲಿ, ಆಮೇಲೆ ನೋಡಿ.
ಅದೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಆಯ್ತು,
ಬಂದ್ಬಿಡ್ಲಿ.
ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್.
ಟ್ಯಾಗ್ ಮಾಡಿ.
ಆಯ್ತು, ನೋಡುವ.
I don't know about the rest of the matters. I can't.
We know.
We also don't know.
ಅಲ್ಲಲ್ಲ.
If you know, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಬಾರ್ದು.
The same notification issued on the same date.
List the matter on again 24th for further hearing. ಇದು further hearing ಇದೆ ಹೆಂಗ್? Yes. Now don't destroy coconut, arecanut, flowers, vegetables. Beetle nut.
ಅಲ್ಲ ಇದು at least on the same day all these cases.
ನಾವು ಇದ್ರೆ ಅದು ಹಾಕೋಣ ಅವಾಗ. Yes.
My purpose is only this. as on today, I mean, till yesterday, my instructions are to the effect that they have not passed the award also.
They will not take any prescriptive action, don't worry. Yes. Bada, Pradeep Kumar is here, he will not do that. If there is a, the petitioners are at liberty to move the matter in the event of need. Yes.
There are some, I mean, apart from this, there are some.
The problem ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಒಂದರಲ್ಲಿ ಕೊಟ್ರೆ the entire batch will have to grant. That's the only reason.
I don't want to disturb. In that case, I don't want.
That's the only reason. Don't worry. I'm hearing it. If there's any problem, we'll take it.
I'll be in the hands of the court, my lords.
Yes. All your flora and fauna will not be destroyed. Don't worry. Yes. Other same. ಎಲ್ಲ ಅದು ಟೈಮ್ ಆಗಿದೆ ಅಂತ ಅಷ್ಟೇ ಹಾಕಿದ್ದು. Again reserved ಅಲ್ಲ.
Grateful.
Same status.
Grateful. Lord.
I'll get some more time on this.
Please.
My lord, serial number 106, my lords.
Madam, it is posted for a purpose, it is reserved. Will pronounce it. It was reserved, it is reserved today also.
Please, my lord, very well.
Yes.
Very well, very well.
Yes.
I'm doing.
112.
Yes, sir. What's happening?
Notification.
ಏನಿದೆ?
Has to place it before your lordship.
Withdraw ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ. An officer has been deputed to.
Officer has
Been deputed to SIT.
Another officer is deputed.
One officer from the cybercrime command has been deputed to another SIT.
So what? That administrative things we can't interfere. The head is not changed.
No, nothing except that.
But your lordship that passed a modem note that the investigating officers will not be transferred without.
No, but that doesn't mean that SIT should not be constituted without these officers. Then we'll be traveling beyond the brief that it is there. That's not, we can't administrate sitting here. And that's beyond the scope of this. But investigation, what is happening?
Supposed to get status report, my lord.
The learned amicus is directed to place the status report of investigation which was called for to be placed today by the next date of hearing, as without placing the report of the investigation as to what is the outcome, incidental orders are sought. Therefore, at the outset, the investigation, the progress in investigation up to the next date be placed before the court on the next date, lest the matter on 23rd. Yes. This we can't interfere. Don't control this.
113.
The respondent.
Petition. Because for dictation of judgment today, it is required under preliminary hearing. Your lordship heard us last week on the IA for substitution. Interlock application, substitution. In the pending suit, I have filed an application for substitution. Order 22, Rule 10 application.
Correct. Reopening day will take it.
Please.
Yes. Reopening day will.
2008 matter, already my evidence is over.
8th October month. Only list the matter on 8th October.
Interim order.
Interim order subsisting will continue to the next date. One vara ashte. Yes.
Great.
List number 3.
List number 3. Release the one-day order, madam. One-day order. Release these matters from the status of being part heard. Post the matter before the bench having appropriate roster. Interim order subsisting in all these cases shall continue till the next date of hearing.
Lord, serial number 1.4 lordship has already heard in lordship.
Ella heard, sir. Yes.
Lord, serial number 1.4 lordship.
Yeah, 1.4 illa everything all released from. We'll come there and take it. Yes. Our roster ಬಂದು ತಗೋಣ ಮತ್ತೆ. Long pending.
ಅಲ್ಲ ಅದರಲ್ಲಿ ತಾವು ಶಾರ್ಟ್ ಕ್ವಶನ್ ಇದೆ.
ಎಲ್ಲ ಶಾರ್ಟ್ ಕ್ವಶನ್ ಸರ್, ಯಾವುದು ಲೆಂಗ್ದಿ ಕ್ವಶನ್ ಇಲ್ಲ. ಇಂಟರ್ ಮಾಡಿ ಎಲ್ಲದರಲ್ಲೂ ಇದೆಯಲ್ಲ. ತಗೊಂಬಿಡಿ 230 ತೊಗೊಳಲ್ಲ ಪಾಸ್ ಆಗ್ತದೆ.
More matters. Seal number 1, Shri MP Shrikant, 48 serial number.
48
Seal number 48, same matter.
ಏನ್ ಮಾಡಿದ್ವಿ ಅದು? ಅದು ವಿಡ್ರಾ ಮಾಡಿದ್ರ? ಹಾ, ಸೇಮ್ ಕರೆಕ್ಟ್ ಸೇಮ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ in the light of the order, see madam, serial number 48 ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ, ಎಜಿಗೆ ಆರ್ಡರ್ ಸೇಮ್ ಆರ್ಡರ್ ಅಂತ ಮಾಡಕ್ಕೆ. ಎಸ್, ತಿರುಮಲೇಶ್ in terms of the memo withdrawn.
Seal number 3, Shri MP Rajendra.
For the petitioners, my lords. This matter pertains to JP Nagar 9th phase, my lords. JP Nagar 9th phase acquisition.
ಅದೇನ್ ಬಟ್ ಕವರ್ಡ್ ಆದ್ರೆ ಮಾಡ್ಬೋದು.
Covered, my lords, actually.
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಹೇಳ್ಬೇಕಲ್ಲಪ್ಪ. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Entry mod for.
ಮತ್ತೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, he is coming for the first time, my lords.
ಎಂಟ್ರಿ ಮಾಡ್ರ?
Demolition ಇದೆ. There is trying to demolish. ಇನ್ನೂ ಒಂದಿದೆ.
Yeah, 1988 acquisition.
ಹೌದು ಸ್ವಾಮಿ, 1988 I challenge that notification.
ಇಲ್ಲ, where are the other orders passed? ಕೊಡಿ.
ಮಾಡ್ರ connected matters.
Tag this petition. ಇದು ಮೇಡಮ್ ಟ್ಯಾಗ್ ಮಾಡಿ ಸೇಮ್ ಆರ್ಡರ್. Yes.
Number 4, S.A. Sudhindra.
Petitioners on a commissioner report, my lords, I filed an objection for the commissioner report, but the trial court wants to take it on without giving an opportunity for me for cross-examination, my lords. Operative
How cross-examination?
Of commissioner report.
What is the order under challenge, sir?
The commissioner report.
Commissioner report. ಏನು? What is the order under challenge? Who filed an application?
My lords, I myself filed an application. Commissioner was appointed. After filed a commissioner report, I filed an objections. So that was not considered. They state that it will be taken on me. It will be considered under the main. The operative portion says, my lords, it's the said objections filed by the defendants will be considered at the time of judgment as it causes delay in disposing the suit anta heli. So I want an opportunity for cross-examining the commissioner report, and there is no extent to what extent is being encouraged.
What's the next date?
My lords, tomorrow, my lords.
Where is the order?
Page 50, my lords.
50?
50, my lords. That's all. Operative portion. 49 and 50. I read, my lords. Even the commissioner is not examined in the light of the observation made by Honorable High Court of Karnataka in Parapana versus Bhimanappa. The commissioner report will become a part of record even though it is not got marked as exhibit. The same can be considered by the court at the time of judgment. Even the objections filed by the defendant for the said commissioner report will be also taken considered at the time of judgment.
So what?
Lords, to what extent the encroachment is there, that is the crux of the matter, my lords, whether there is an encroachment or not. To identify that,
Suit for?
Declaration and possession. It's the plaintiff suit for declaration and possession. I am the defendant. To what extent they say that eastern portion of some 3 feet is
But judgment ಗೆ ಹೋಗಿದ್ಯಲ್ಲ ಆಗ್ಲೇ?
ಇಲ್ಲ, judgment ಇನ್ನ ಹೋಗಿಲ್ಲ.
ನೀವು ಹೇಳಿ judgment
arguments of defendants.
Then serve ಮಾಡಿ, we'll take it on another day. Stay ಮಾಡಿದ್ರೆ ಏನ್ ಬರುತ್ತೆ? You are the plaintiff.
I am the defendant, madam.
You are the defendant. You filed an application.
I filed an application.
Your application is allowed.
Applications is allowed, my lords.
allowed.
A commissioner was appointed.
Report of
but
the commissioner is in
unfortunately,
place.
Either the plaintiff or the defendant were present at the time of commissioner.
ಯಾರು ಇರ್ಲಿಲ್ವಾ?
ಯಾರು ಇರ್ಲಿಲ್ಲ. That is also observed in this thing. And the purpose of this petition, the application itself is not visible. So there is no, to what extent it has been encroachment ಆಗಿದೆ ಅಂತ ಎಲ್ಲೂ specific ಆಗಿ ಹೇಳಿಲ್ಲ. That is the reason I stated in my objections also, my lords. My lords, 43 annexure F is the objections. The commissioner has not identified and demarcated the extent of the encroachment and has also stated in the report that he could not get the details of the court file and without any instructions and without following any instructions filed by either of the parties before this honorable court, the commissioner has only for the sake of his appointment as a commissioner has just submitted the report without coming to the spot physically or conducted in the matter. That is my objections. Annexure 43, my lords. Page number 43, annexure F, my lords.
Judgment ಹೋಗಿಲ್ವಾ definitely?
ಇಲ್ಲ. It is for the defendant's arguments, plaintiffs agide arguments.
The petitioner, the defendant is before the court calling in question an order dated, date ಅದು
17/6/25,
17/6/2025, by which the concerned court holds that the objections of the petitioner, the defendant, would be considered at the time of the order being passed. The learned